Good evening, and thank you to all the participants who have taken this time out to join our webinar on the topic Navigating GST Investigations and Best Practices. On behalf of Grant Thornton Bharat and my esteemed co-speakers, I, Krishan Arora, Partner, Tax, Regulatory and Finance Consulting, am pleased to welcome you all to this session. As part of the coverage in today's session, we will explore various facets of GST investigations, the preparedness required by taxpayers, their rights and responsibilities, along with some key aspects to keep in mind when a process of investigation is initiated and while engaging with the authorities during the course of these investigations. I have the privilege of moderating this session and taking you through the discussions as we hear from a distinguished panel of experts who will share their perspectives in addressing such investigations. Before we dive deeper into the discussion, it is important to highlight the magnitude of recent developments in the space of GST investigations. According to the latest reports issued by the Director General of GST Intelligence, that is DGI, which is the apex intelligence agency under CBIC, there have been close to 6,000 cases of tax evasion in FY 23-24, crossed INR 2 lakh crore rupees of tax amount, almost double of the amount that was reported in previous financial years, financial 22-23. Key sectors include online gaming, BFSI, that is banking, financial services, and insurance, pharma, along with specific services like works contracts, OIDR, which is online information database access retrieval services, brand licensing, transfer of leasehold rights, etc. And these have been under close scrutiny and thoroughly investigated by the authorities in recent times. In 23-24, the GST Intelligence Wing has flagged online gaming industry as high risk and initiated actions against both domestic and offshore and online gaming entities, involving a total tax liability of about 82,000 crores in about 78 cases. This was followed by BFSI sector, where approximately 19,000 crores of evasion was detected in around 171 cases. Works contract and pharma sector were also identified to be amongst others, where the tax involvement was around INR 2,900 crores, including tax evasion. This list also extends to evasion identified in sectors like iron and steel, alloys, scrap, pan masala, tobacco, plywood, paper, electronics. The agency's focus is now shifted towards the untapped OIDR services, as I mentioned, which is a B2C mode of foreign tech-driven services to Indian end customers, where revenue has grown significantly from INR 80 crores to about INR 2,500 crores in the last 6 years. With the surge of GST investigations, it becomes imperative for taxpayers not only to look at the technical interpretations, legislative provisions, and judicial precedents around these issues, but to also have a clear understanding of the procedures involved, steps involved, being fully aware of the rights and responsibilities. Navigating some of these investigations require not only a deep knowledge of compliance, but also strategic approach to dealing with authorities in an effective and cooperative manner. I will now take the opportunity to introduce our panelists for this important discussion. They collectively bring a wealth of experience, knowledge, and insights insofar as dealing with and handling of various sorts of audits and investigations is concerned, both technically and practically. So please join me in welcoming Mr. Gurmeet Singh Sukhija, Indirect Tax Head, Mankind Pharma Group. My colleagues at Grant Thornton Bharat, Mr. Govind Singh Puri, Partner and Leader Crisis and Resilience at Grant Thornton Bharat, Mr. Manoj Mishra, Tax Controversy Management Expert and Partner at Grant Thornton Bharat. Before we begin, some quick ground rules. I would request all participants, if you have any queries or clarifications, you please submit that in the questions in the Q&A box at the bottom of your screens during the course of the session. We have a team led by our GT National Tax Office representative, Ms. Shilpa Verma, who will be working alongside with us to address those queries in parallel and towards the end of the session, if time permits, and ensure we make this discussion as informative and insightful as possible. Once again, ladies and gentlemen, thank you for being here with us today. I will now hand over the next set of discussion over to my colleague, Manoj Mishra, to take you through key aspects related to investigation, followed by a brief practical perspective, which will be shared by my colleague Gagan before we get into our panel discussion. Over to you, Manoj.
Thanks, Krishan. Good afternoon. So before I start, there is a famous dialogue in a movie called, it goes like this, that कानून अंधा होता है, judge नहीं. And in my opinion, an investigation, if done impartially and properly, could be a light to enable the judge to see the facts and do the justice. With this, I'll start my presentation, where we will discuss about, first we'll discuss about the legal framework around investigation and how the government officers are empowered. Next slide, please. So when we, in any investigation, there are three things which are important. First is person, second goods, and third would be the documents. And for that, inspection of goods would be through search and seizures, whereas for inspection of person would be by way of summons. For that, legislative empowerment has been given under Section 67 of the GST Act, which empowers the person not below the rank of Joint Commissioner to empower any officer to investigate any matter where they have reasons to believe that it could lead to suppression or lead to invasion of GST. And in such cases, they can investigate any person, goods, or the premises. Similarly, Section 68 empowers inspection of goods while they are in movement. Similarly, for inspection of inspection of goods and the premises, there is a provision of search and seizure which empowers that with a proper warrant, any premises, or whether it is business or residence, can be searched upon to find out if any goods which are supposed to be confiscated, or the documents which can be which are crucial for any kind of investigation, or which may lead to unearth any GST evasion. Third, then there would be, once it is established that there are reasons to believe that goods or documents are required for any investigation, then the Joint Commissioner or the officer above can empower any other person to access into any premise to look for that such goods or the documents, or even the system like computer systems, or any other manner in which they feel that they can find those goods or the documents. Once they this process is done, then they can summon any person. If they believe that any person is holding any information, they can summon that person to present and give statement and answer to their questions to ensure them that all the information required for investigation are answered properly. If required, if they believe that there could be reasons for duty evasion, they can provisionally attach any property to ensure that revenue of the exchequer is safe. If they believe that any person is evasive or may prove crucial or can tamper with the evidence, they can arrest that person. However, whether that person can be arrested or not, whether this provision of arrest is uh, valid or not, is under question. But as of now, the high courts have given decisions in favor of the government, and government is making arrests in case of duty evasions. Next slide, please. So as Christian mentioned, you would see that since inception of GST in 2017-18, the cases which DGGI has unearthed has gone 25 times from in 2017-18, which was 7879 crore, has gone up to more than 2 lakh crore in 2023-24, a 25% jump. Whereas collection or recovery during these investigations have jumped only like around 3.5 times, mainly because of various instruction where it was clearly mentioned that during the investigation you cannot recover the money forcefully, so that perhaps help assessees to escape payment of taxes during such investigation. If even like if you look at the areas where DGGI has mainly focused upon. They have issued around 20,000 notices across nation from 2028 to 22. Pharma, gaming, etc., have been the major focus area. Recently, they were investigating foreign airlines. Thankfully, better sense prevailed, and in this GST Council meeting, they decided to forego this revenue. And in even like fraudulent GST ITC claims are such is something where it is already from where the DGI investigation actually started, and as of now, as per the information available in the public domain, they have unearthed GST evasion of around 20,000 crores where GST invoices have been issued without any supporting or without any supply of goods or services. Next slide, please. So, as Krishan briefly touched upon, that sectors which are under the scanner. So there can be two areas where generally investigation will take place. One, where there are disputes related to interpretation, and second, where the cases of actual evasion. Here we are talking about the areas where interpretation would be an issue, because invasion can be in any of the areas which we cannot foresee. But what we can talk here about, the areas where disputes is on account of interpretation, and DGGI has, as of now, has issued someone and pointed those areas. Of course, online gaming is the top priority, where revenue of around the so-called notices worth a lakh of crore has been issued. Then pharma sector, where because of its peculiar nature, related to intellectual properties and shelf life of that of the product, the issue is under scanner. Long-term lease is another interesting area, because in most of the cases, people are not even aware that they are required to pay GST on that. For example, in North, mainly, suppose you take a land on lease and construct building on that, and if you are transferring that building along with your factory, then you are required to pay GST. Most of the people are not aware, and even if you advise them that you'll have to pay GST, they'll feel that what you are talking about. Yeah, why I have to pay GST on land which I have taken on a lease for 99 years? So these are certain areas where dispute is on account of interpretation, but are under the scanner of DGGI. Then insurance sector, very interesting case, because as per IRDA, there is a fixed commission which can be paid to the agents, where these insurance company want to pay more, and they get into some other kind of services with them, and for them they pay, and then there is a issue that you have availed credit without supply of any services. So that is another issue, and so-called notices was lakh of crores have been issued in this particular case as well. Then OIDR is a new subject or new area where the investigating agencies are focusing on, because most of the things have become online, and in online transactions are very difficult to catch, and in most of the cases the service provider is situated outside India, and chances of evasion are high. So this is the focus area for authorities as of now. And of course, cryptocurrency is the new thing. Everybody, most of the people are not aware about the consequences. So it is bound to come under the scanner of GST authorities. Next slide, please. So how GST investigation generally starts? So gone are the days when they were solely dependent on the documents. Now we are living in modern era of information technology and artificial intelligence. And thankfully, government is one step ahead in when we come to technology. So they have their own mechanism of intelligence gathering, and that is based on analytics and artificial intelligence. I can share in one particular case. I was discussing with one of the commissioner, and they were discussing and sharing like insight which I was not even thinking of. So they says that how they detect evasion. They says suppose we have an area, industrial area, and if power consumption of any particular industrial area is going up, and there is no consequence, there is no increase in revenue, then it creates a doubt that if power is going up, power consumption is going up, there should be output, there should be some outcome related to that. And if our revenue is not increasing proportionately, then there is something wrong. There is something wrong. Similarly, if like number of manpower in any particular area, number of manpower employed in any particular industry is going up, but there is no subsequent increase in revenue, then there is something wrong. So this kind of data help them to gather intelligence and prompt them to focus on any particular industry or particular area to see whether any duty evasion or any tax evasion is going on. Then, of course, they have mechanism of routine audit and the scrutiny, whistleblower complaints, mostly employees or the other individuals who has knowledge of the business. Sometimes it could be your competitor, sometimes it could be political influence, or sometimes decision like subsequent Supreme Court or High Court decision on any particular aspect that also create investigation. As I mentioned, detection of unusual trends and mismatches is a trigger point for GST authority to start any investigation. And third-party reports are being shared with by indirect direct tax authorities, SEBI. So, for example, if any income tax rates take place at any particular premise or any particular company, and they ultimately end up paying income tax showing that XYZ income has not been declared to the government. It immediately will trigger GST authority that if there was undeclared income, then there should be evasion for GST also. So they will it will be a trigger point for them to come and investigate whether GST has been evaded or evaded. Then there could be sector-specific drive. We discussed in the previous slide that various sectors are under scanner of the government towards GST evasion. Next slide. So when there could be scenarios for GST investigation. One, that could be against the company, obviously, which is normally the case that GST authorities are investigating any particular company or any particular industry. So they are coming, issuing summons, asking for the records, data, and they DGGI would have jurisdiction all over the company, so they can. So a person, a DGGI officer sitting in Mumbai can issue summon to somebody sitting in UP to provide records because it may be necessary for his or her investigation. Then investigation could be of key management personnel or the employee who may not be directly involved. So suppose a production manager in a manufacturing company may not have any kind of relation with GST documents or GST authorities, but he can be summoned, he can be investigated to prove because he may have certain specific knowledge which can help GST authorities to unearth any revenue leakage or any revenue evasion. Similarly, if a company is being investigated, then to ensure and to collect evidences, its vendors or the customer can also be investigated or may also be subject to summons by which they would be asked to they may be asked to provide certain information related to that particular company. Next slide, please. So during this investigation, obviously, since it is a democratic country and be fair and just, taxpayers will also have their rights. So first right is right of retraction. So suppose by any chance you have given any wrong information or something which you believe are factually not correct, or something they ask you to do or write forcefully, you you should retract at the first instance that whatever you have said is not correct, and provide them the correct information. Ask for the reasonable time wherever you are not certain about anything. You ask that you are not aware, and you ask for the reasonable time. Wherever searches are being taking place, ask them to provide you the warrant. You ask them to present themselves for the search, or ensure that if a residential premises being searched, that a lady officer is available with them. They can come to you for a specific purpose. So there has to be a warrant saying that the investigation is for XYZ purpose. So if XYZ purpose is completed, or if XYZ purpose is defeated, so if they are coming to say search for any particular document or any particular goods, and if they are not able to find that particular goods or the document, then they cannot start looking for some other goods or other documents. For that, they will need to have a separate warrant. So please ensure that all these things are taken care of while they are anybody coming to search any premise. Then, of course, right to remain silent. It is very important, because right to, if you are saying something, can be something wrong, can be misused against that particular person. And though it is saying that defendant has right against self-incrimination, but at that point of time, the person is only under investigation, not the defendant. So anything said would be used against them, and that would be a valid evidence. So if any point of time you are not sure that what has to be said, please remain silent, and they cannot force you to say something which you do not want to say. Then right to cross-examine. So if anything you, that is at later stage, if anything is said that you have said this, or XYZ has said this against you, you have every right to cross-examine that person to ensure that whatever he said against you is it should be either based on proper evidence, or if misconceived, should be rectified. And right to inventory, whatever being submitted, in any case they are required to, because otherwise they will not be able to use that against you. In any case, they have instruction to issue panchnama, but you also ensure that they have included everything in the panchnama, and they are not taking anything not mentioned in panchnama with them. So ensure that whatever they have seized, they should give you inventory of that. Next slide, please. So, of course, when you have rights, you have duties as well. So, a person has to maintain proper books of accounts up to 6 years, and in case there are disputes, it has to be maintained till the time disputes carries on. So you'll have to maintain that records and produce as and when being asked for by the government authorities. You have to cooperate with the investigating agencies, be nice to them. Be nice to them. Be nice to them does not mean that you adhere to or give in to their unjustified demand, but be courteous and treat them as you would have treated in any visitor at your premises. You should attend to the summons as and when it is issued, because it is mandatory. And you submit the documents on timely basis, or as and when you promise them that you will submit, please submit that document. And if you are not able to submit by then you go and ask for more time and tell them that by this date you will be able to submit that. Next slide, please. So there are, of course, since we are talking about investigation, so there would definitely be some areas of concerns. And like here, we are saying the force, and we discussed in the first slide itself that force or spot recovery, though it has come down drastically, because of various instructions from the government, various instructions from the department. But even today, they many a times they try to force upon recovery during the investigation. So it depends on the auditee, or depend on your nature of your business. You believe that something is due, then pay it upfront to avoid any notice. But if you are of the firm belief that you are right, don't give in, as they do not have any legal right to force you for any payment during the investigation. But then there could be simultaneous investigation or audit. Audit can go on because there is no restriction on that. But in case of other investigation, there are various instructions by which it can be ensured that only one investigation is taking place, not multiple, if they are focusing on one particular aspect only. But if they are the two authorities are investigating different issues, then they can carry on with that. Many a time they tend to pressurize the assessee. They tend to issue summons in the name of key management personnel or the employee. But there are instructions. But once summons are issued, it has to be followed. Then another issue is going on if they receive or there are cash which found during the investigation, whether that can be seized or not. So there are contrary decisions, but as of now, the settled position is that cash cannot be compared with goods and cannot be seized. Next slide, please. So best practices would be that comply with the proceedings. Before saying anything, you obtain a complete understanding of the facts, submit only verified data, or if you do not have that data, seek request further time and submit only if you are sure about the data. Order sheet, wherever you are signing, read that very carefully. Do not sign anything until unless you are fully sure, or you believe that whatever you are writing or whatever you signing is correct. Wherever you are signing, put date, a current date. Don't sign anything on the back date. If you can request them to record your statement in local language, if you want that. You can also do proactive representation before the authority, that if you believe that your industry is being investigated, you may reach out to your officers and provide them all the data beforehand, before they come to your premise. And refrain from stating anything incorrect, because it can be used against you, and it can be they can levy there can be allegation of suppression if you are providing anything incorrect. So at any point of time, do not say anything which you are not sure of. Don't avoid someone, because it may lead to arrest. So please be there. If any someone issued in your personal name, if it is issued in the name of company, please ensure that one of the authorized signatories is there to represent the company. Key to come out of investigation is that don't get panic. The moment you are panic, you will put yourself as well as your organization in trouble. So ensure that you do not get panic. And while I am saying all this, I assume that whosoever getting investigated, and if we are talking about our clients, they are honest and they are investigated. Just because department is of the opinion or investigating any particular industry, so they are being investigated. So we believe that you are honest. So don't get panic and act wisely. Do not promise anything that, okay, you go today and we will pay you this much of tax or revenue. Don't promise anything. Otherwise, it may lead them to believe that you have done something wrong, and that's why you are ready to pay so easily. So they may go deep into your affairs. Whenever they are asking you anything, until unless you are very sure, do not rush to provide information. Take your time, understand their question, understand the implication of whatever you are saying before providing any of your response. Don't give the information which they have not asked for. You do not know. You may be saying in a good faith, but they may take it otherwise, and it can lead to some another stream of investigation. Don't do that until unless you think that it is going to help your cause. And until unless you are officially authorized to say something, don't say anything. You may always refer to the person who is actually authorized to take up those questions, and don't come forward and say anything unless until you are authorized by your organization to respond on that particular question. So next slide. So now I'll request my colleague Gagan to throw light on key evidences used by authorities. Gagan, over to you.
Thank you, Manoj, and good afternoon, everyone. I think Manoj has already set the context in terms of what one should look for, and my experience of over 2 decades now on handling investigations of various sides, and now over the last couple of years working a lot on the GST side, has come out with some very interesting sort of connotations to it. I think, firstly, the concept of evidence, as we've seen, has really evolved. We always talked about evidence used to be in writing or it could be oral, but now increasingly the third category, which is electronic evidences, has become extremely important. I think it's a lot of the investigations on the GST side we see today. A lot of it is actually based on electronic evidence, because if the department can't find it in the documents or what somebody's told them, then the other is to look at the sort of the verbal communication now that happens in the electronic and in the cyberspace. So it's become really important, and that's become a big game changer actually over the last few years. And the sources we've seen, earlier it used to be something you would provide to the department, they would look through it, and then they would come back with questions or based on that. Or it would be some research the department has done. But now increasingly we are seeing another source, which is the triangulation of information that other assessees may have on you. And now with the way digitization of records has happened, digitization of communication has happened, it's much easier for them to triangulate all of that and present that evidence to you. And I think that changes the context of what they look for when they come and ask you for evidence, or when you are called in for investigation, or you called in for a summons, and what you are confronted with at that point in time. So I think it's important to recognize that the concept of evidence today is really vast. It's not a narrow subject anymore on what you may have provided, but it's actually a larger set that could be out there on which you may be asked to provide clarifications or there. And again, the context of evidence also changes as you look at the life cycle of an investigation. So in, let's say, a show cause notice proceeding, they will ask you to volunteer information, or ask you for information related to your transactions, your books of accounts, give your secretarial filings, your information on your vendors, GST, stuff like that is what they would ask for. But when it moves to a search and seizure, or even to a litigation post search and seizure, the context of evidence also starts evolving and changing at that point in time. So evidence is there. There's a lot more reliance on, as we call it, your state, your mental state at that point in time. What communications went out, what emails people exchanged within the company, how was the data prepared, in terms of what's been looking at, and again, kind of putting it there. So really the differences between how you respond to a show cause notice versus what you provide in a search and seizure versus what you again provide in support of your sort of your case in litigation. One needs to look at evidence into all that context. And I did mention at the bottom of the slide something called utmost care. And from our experience, I think this is where we see a lot of difficulties coming in. It's a downright, I wouldn't like to use the word carelessness, but when a search and seizure is happening, or the department is looking for evidence, at that time people are so fixated, okay, let's give it and get over with it, that they at times overlook certain hygiene factors which become very important when you're providing evidence. And try to give you a few examples. Firstly, keeping a record of what is provided is very important. Panchnamas and search and seizure notices, search and seizure memos are at a very high level. But really detailing out what went in, it's very important. So if the department doesn't document it, you should immediately step back and document it post the search and seizure operation. So it's very important for you to have a holistic view of what exactly is collected from you at the time of the search. And I think we've seen a lot of cases that come up on that. Second is preserving the sanctity of what is provided. The department comes and says, okay, give us emails of Mr. X. So the emails are downloaded on a pen drive and they're just provided, and a record of that email is not kept with the company. Now that becomes a very big problem, because tomorrow when you go for questioning or you go to attend a summons, right, they will be showing you emails, but you will say, oh shit, I've not looked at it, because you've not done an accurate mirror image of what was provided to the department yourself. So it's a very important thing that whatever is provided, whether it's electronic, whether it's physical, whether it's oral, you try to maintain a mirror copy with you, because you don't want to be in a situation tomorrow where you are out of your depth, sitting before a government officer, and undergoing an investigation, and you have nothing to defend yourself with, or what you have to defend yourself with is something very different from what the department is showing you at that point in time. So that's the other part. The third, it's very important to maintain a procedural control over what is provided. So at times when the department comes in today, they will go to a person's computer and they will say, okay, I want a copy of this person's computer, and they will do a forensic imaging of the computer. Or they will tell the person, open your Gmail and I want you to download all the emails you have from the past 15 months onto a pen drive and give it. Now that procedural control over how you get that data is very important, because tomorrow in your own defense, you have to replicate that data again. So it's very important that you recount, and immediately after the search, you list down the exact procedures you followed to get to that information, because you will again need to create a working set back with you. So it's again making sure that a procedural control over what is provided is there. And I think they're just kind of two quick concluding points before we get on to other things. I think my two concluding points. One is, it's very important for you to have a searchable repository with you of whatever is provided, whether it's electronic, whether it's accounting information or any other documents, including testimonies of people that are taken. It's very important to have a searchable repository, because as you answer to show cause notices, as you answer to further questions, as your employees go for questioning, they need to know what is out there in their regard, which has been taken, so that they can assist the department in a more comprehensive manner and not come back looking like a company of people who have no idea of what they were doing or what actually has been taken. Because, at times knowledge and information becomes very dated. I maybe asked a question 3 years back or 4 years back related to a transaction. I may not have that knowledge today, but if I have a searchable repository, either I can answer it at that point in time, or I can go back, check, and go back to the department with a comprehensive answer of what was asked for me. So I think that's part. And lastly, I think it's also important at times when you look at these evidences that you have provided, is to do a self-review of it before you go for proceedings, because you should be informed enough to know the sort of the syllabus, for lack of a better word, in terms of what you may be asked for. Again, it's not always comprehensive, because there may be out of syllabus questions which you don't know, which the department may have from research they may have done outside, but it is at least important to know from your own books, from your own communications, from your own information, you are able to have some semblance of why you're sitting in front of the officer and what questions you're attempting to answer. So I'll stop it at that, but happy to field any questions on this later. Back to you, Manoj.
Thanks, Gagan. I think a lot of insights in terms of the practical aspects which you just talked about in terms of the evidence, which is very, very crucial. I think Manoj touched upon a couple of aspects in terms of, what are the best practices in terms of what we should be actually mindful of while going through an investigation. At this point of time, I think my question to you back, Gagan, is, having talked about the evidence and having talked about the electronic evidence, what is in your experience the top probably 2 to 3 things which a client should be actually mindful of or taking care of as a top priority while addressing a SCN or a search and seizure exercise?
Yeah, so I'll give it in quick succession. My top one is data preservation. Whatever you provide to the department, you make sure you have an identical forensic copy of that data with you. I have seen so many cases when the department later on says that there's a document, and the document not from you, but you are then struggling to figure out, oh shit, where did that document come from? But if you know it's not in your data, you can go back with a counter argument and say, this is not something you had taken. This is not something I provided you. I need to know, you need to explain to me the source of this document and the context in which you're asking me to provide information on it. So data preservation is the first one. The second is data accuracy and consistency. Every time, and there's so many clients who engage us just for this purpose, that they want us to cross-check the data that's been provided as evidence to the department. Whatever you provide is evidence, and you cannot provide wrong evidence or incorrect evidence, because if you do, and the department bases its conclusions on that, you then run other risks of being, providing misleading or falsified information, and they can absolutely make that, even if you provide it unintentionally, there's a different connotation to it. So making sure that there is consistency and accuracy. And last, and I think Manoj had alluded to that, so I'll just kind of pick one more point: do not commit perjury. Do not make a statement based on your gut feel or based on what you think may have happened, or intentionally mislead the government in any way, because that is perjury, and you should absolutely steer away from anything. You can use whatever you have in your records as in support of your matter, but creating evidence and then providing something that contradicts yourself, is a cardinal sin and must kind of be steered away from. So those would be my top three.
Absolutely. I think data preservation, data accuracy, and the communication which you actually make to the authorities, one needs to be really mindful. I think we've talked about it from an expert perspective. I'll bring in an expert from the industry now. Gurmeet, thank you for being here. I think you heard what Manoj and Gagan talked about, but what's your thought in terms of the insight which you could share in terms of the stakeholders' view, or the on the industry view, in terms of handling the investigation processes under GST, and what concerns or practical challenges do you see commonly which are raised?
Thanks, Kishan. I mean, it's an enriching session by Manoj and Gagan. So, though Manoj has picked up most of the points, but we all would appreciate that today's investigation process is complex under GST, and it certainly adds to the compliance burden. One more important thing that it has, a challenge rather it has created for the business is the reputation risk. We have all seen our notices flying around that, TCS or Infosys has got a 32,000 crore notice. There's a brand issue for M&M. We have seen the same for the gaming industry as well. Now for the investigation, I mean, obviously we all understand that investigation is going to happen, because one thing is for certain, that department wants to check the tax evaders, etc. However, the challenges that it poses for the for the industry, I would summarize into 3 points. One is the transparency and fairness. In most of the notices, what we have observed, that whenever you receive a summon or you receive a notice, it says that okay, you have not paid input tax credit as per the provision of the law, or you have short availed and not paid the taxes. Now, at this point of time, it is very important for the industry to know what is the basis behind this investigation. It may be coupled with the legal framework and the ambiguity in the GST provisions, as we have talked about the leasehold provisions or the brand provisions. Very interestingly, in this month itself, there is a circular on ITC availability on demo, in which the language which is being used by the legislative itself, that the intention of the law appears to be not to deny the ITC. If the legislative function is not clear on the intention and it resorts to the purposive construction, then it is very difficult for the industry people to even comprehend what is the interpretation. And investigation on the interpretational issue, I think it should be modified, or it should be toned down by the investigation authorities. Because if I'm taking a position, as a tech said, if I'm reviewing a transaction, I'm taking a position, it is my best information, my best knowledge as per the provision of the law. It does not necessarily say that if the taxation authorities have some different interpretation, then it will lead to an investigation. So there has to be some communication channel between the industry and the government to mitigate the same, or to eliminate it before it reaches to the show cause notice. Another important aspect or challenge, I would say, which we face, is the prolonged or protracted investigation. We have seen many a times that the investigation starts and it is running for a year basis. And in between, you face these challenges that the officer gets changed, and they are asking you the data for again and again. And sometimes, you are on the verge of the closure, and then immediately you see that, okay, the officer has changed and he's again asking. And the important thing, even if the investigation starts, where is the closure? Do we have a timelines in the law Interestingly, in a couple of days back, I'm having this discussion with the very senior member of CBIC, and I actually raised this point that how do the industry guys or the people like us will be sure that if even if we are providing the data, how is it that we are going for a closure of the same? Because you keep on asking the data, and unless we receive a SCN, how do we know that our data satisfies the requirement of the people on the taxation authorities or not? So these are the three major challenges. I mean, what I feel nowadays, which the industry is grappling with.
No, I think absolute perspective in terms of what you said, Gurmeet, that the process itself has challenges, and I can vouch for the fact that, and all of us can vouch for the fact that it's very painful if the officer at last minute or any point of time is there a change which happens. There is no communication. You just come to know that an officer has changed, and after that everything starts afresh, and you wonder where did I start from and where have I reached. And all that
Absolutely.
ground I covered, I'm actually going to be repeating everything in front of somebody who's going to look at it afresh. So yeah, absolutely, you're right. This is something which has always been a concern. But this also becomes an area of improvement. But do you think any other areas which you feel which government should look at simplification in terms of the certainty, having had dialogue with the industry and very well CBIC, GST Council are very open to dialogue these days. If there is a chance of them having that dialogue before the investigation starts, I think there is a lot of ground which can be covered in that also. So do you think are these any areas of improvement which you see in the process itself, which can help the industry as well as the investigating authorities to actually make this process simple as well as more effective?
Well, certainly there are a lot of areas of improvement, and repeatedly this has been asked of the industry, and I'm sure that GT is also engaged with the higher for us of the revenues on this. One thing which is mostly required is the training to the tax officials. The intention of the government is fine. I mean, we know that, as you've mentioned, that GST Council is open to the recommendation. You can reach out to the commissioner or the council or the special committees or the secretaries of the department. They will listen to you, or maybe they will issue a notification. But how do you implement it on the ground level? I'll give you an example. Recently introduced Section 128 Capital A, which is a mini amnesty scheme. Now, I have raised this question to the secretary, TPRU, I mean, in a recent discussion. So I've asked one simple question that I'm sure that you have mentioned the date November 2024 for its implementation. There has to be some rationale. We are not denying it. But how to ensure your tax officers that they would, accept this fact that this kind of a provision is coming and they should allow you some benefit,
Yeah.
right? Government has issued various circulars for DGGI that okay, you will not issue a show cause notice without concerning us, and there should not be any summon, and you should not issue a vague language or use vague language. But most importantly, how to implement these efforts on the ground so that the benefit should reach to the taxpayers, or I would say the honest taxpayers who have done everything. Because as a tax head, what important for me is the tax certainty. I don't want to have a sleepless nights after taking a position. So
Right.
the areas obviously that we should seek some tax certainty from the department, from the government, and the measures that the government are taking, they should actually be percolated to the ground level. And obviously the simplification procedure, even after simplifying the things, there has to be some mechanism. If a particular industry wants to have particular view, a view should be issued to the particular industry as well. As you have mentioned, the leasehold land, or there are certain issues with the pharma industries or the auto industries. That is very important, because sometimes what is happening with the pharma industries, a perfect example is the circular for credit note issuance on the expired or the
Yeah.
expired medicines. Now that circular is specifically for pharma, but it also applies to the industry at large. And pharma itself is in the fix because of the language used in the circular. So there has to be some mechanism where if a particular industry is affected, there has to be specific, notification or a circular or clarification for that industry. That as of now is not happening, wherein a request has been made to the government, and I'm sure you guys must be, in deal with the CBIC. There has to be sector specific committee which should be formed, to look at these specific issues, because even after 7 years, even government accept that GST is at its nascent stage. We're still having, litigation cropping up even after. I mean, I've been told that there are more than 100,000, 1 lakh show cause notices which has been issued in the last year itself. And out of that, only 500 notices with respect to the classification. So these things adds to the compliance burden, which should be, toned down or try to mitigate it.
Right. No, absolutely. I think you said some of the very valid aspects in terms of how one is, we are willing to cooperate, as what I heard, industry is willing to cooperate, but there are interpretations which are always welcome to both sides of views. There are clarifications. There is an attempt by the CBIC or the GST Council to address those issues, but it's also important for the agencies to also be mindful of those and also take dialogue and consultation from their side as well before they actually proceed on these investigations. I think that's something which is very important as far as the process is concerned. Any thoughts in terms of a top point for you to say what is it that a tax expert from industry perspective like you would be mindful of in handling an investigation?
I'll pick it up from where Manoj has said that don't panic. Now,
Yeah.
the only, the better or the best part to not to panic is to have confidence in your position. As we have, discussed that the majority of the investigation is because of the interpretational issue. If I have taken any position, I have to be confident. And how to be confident? I mean, my advice or my thought would be to have a tax advisor or a legal advisor. It always helps. You should have a proper documented position. Wherever you are taking any position, you should have a proper legal backing of it, that why are you taking, and obviously have a proper control over the documentation. Obviously, we have seen many cases where, people do panic in responding. It is good to respond promptly, but it is also very important how to and when to respond. It is not, I mean, as Gagan has mentioned and Manoj also, mentioned that do not respond what is not asked for.
Yeah.
It is very important. And it is also important to know the scope of the investigation. Every investigation is not a search and seizure. And every ASMT 10, you cannot say that it's an inspection asset. So you have to be very, vigilant of the fact from which authority you're receiving the notice and what sort of documents they have asked for, and be very aware of your rights. Sometimes, I mean, it happens that the investigation pertains to financial year 1920, but they will ask you the data till date. So it's important. You can obviously say no to that, and whatever is not relevant, you can mention that. But out of everything, the most important thing for me, as a if I need to be secure in my position, is to seek a professional advice. That I would like to highlight.
Absolutely. I think easier said than done. Whatever we do in terms of the interest of the company, I'm sure professional advisors always help, and you have always been vigilant to do that. And thanks for that answer, because that is very, very important, the way you actually address this point of what are the areas to be mindful of, rather than saying that, let's just provide everything. And, in that hustle of doing things, we don't realize that in the excitement, we miss out on certain things, or we actually over provide things which are not relevant, and that could lead to additional pain for us as well. So absolutely rightly mentioned that. I'll move back to Manoj, and I'm mindful that we've only got 6 minutes, so I'll be on a rapid fire to all three of you in terms of last three questions. So Manoj, I think you touched upon the fact that where the investigation is happening for a company, there is also companies and suppliers, or consumers which are in different states, which also can be reached out to for seeking information by way of summons. So in such cases, if the GST officer issues summons to companies, in this case, what kind of action is valid or can be contested by courts sitting out of one location to actually seek that information from another jurisdiction?
So, Christian, in general, the officers are bound by the jurisdiction. So
Yeah.
a central CGST officer would be CGST officer, or the SGST officer, they would be bound by the jurisdiction for which they are in charge of. So it is not that any CGST officer can issue someone to any company outside his jurisdiction. But yes, there are certain central agencies like DGGI,
or the agencies or the person who has been specifically notified to be the designated officer for this purpose, only they are authorized for cross jurisdiction or having pan India jurisdiction. So whenever some such kind of summons are being issued, it has to be looked upon whether the agency or the person who has issued that summon has got empowered, or he has issued someone just because violating his rights of jurisdiction.
Right. And I was just, going back to what Gurmeet was saying, and officers change all the time and investigations become more painful. It's also possible that in the industry, when the investigation is going on, summons are issued to former employees who left the company and still get, are they really accountable for those activities of the event which have occurred during their employment tenure? And for that, the question is an ex-employee bound to comply with those summons?
Unfortunately, yes, Krishan. So any
Yeah.
person, whether employee or not employee, previous employee, they are bound because the word uses any person. So it
Yeah.
doesn't matter whether you are in employment or not. So I would say that if you foresee such kind of any such investigation, be in the employment, because till the time you are in employment, company is going to bear your expenses as well as the day. Otherwise, if you leave that organization, everything would be at your own cost.
Right. And I think, Gagan, you talked about electronic evidences and evidences playing a crucial role. So why do you think the preservation is so important? Because I know in the era of now documents becoming electronic, what is that role of electronic evidence, which will be the most important, crucial part in the GST investigation?
Yeah, I'll keep it very brief here. I know, be
Yeah.
conscious of it. I think the very simple part is electronic communication provides mens rea or culpable mental state. And for me, the very fact that, either you are culpable or not, a document may prove that a transaction went in a certain way, but it's really the electronic communication that proves the intent behind it. And the department is looking for intent. So for me, preserving that electronic information, looking at it properly, and making sure it gets the attention it deserves, I think is a matter of fundamental importance. WhatsApp, Telegram, Gmail, Proton Mail, like whatever you use today, department is liable to come here and ask for it. And that's where your culpable mental state comes from. So, I mean,
Right.
it's probably the most significant part of whatever investigation happens today.
Right. I think we also talked about the investigations being held and people getting summoned at the management level. But the recent changes in the Finance Act also allowing the authorized representatives to respond to the GST summons in place of the people who have been issued those summons. What are the key aspects a business should keep in mind in that case? This question I'll ask you, Manoj and Gurmeet, your view, the last one on that, in that order.
Kishan, so Section 70 has been amended but not yet notified. It says that the person can authorize any other person subject to approval from the government officers. And that authorized person may go and represent like in someone. So yes, maybe mainly to facilitate or mainly to ensure that key management personnel are not troubled or with the investigation. So and the person who is actually responsible should come forward and provide documents and the information to the authority. This provision has been enabled. But yes, again, since it is subject to approval from the government authority, we'll have to see the success of this particular provision.
Gurmeet, your views on this?
Absolutely, Krishan. This is a welcome move. However, the language which is adopted by the government, that if it is in the hands of the officer or the government authorities to allow, the representation to join, and it has helped the organization because there were a lot of summons which being issued to the KMP, which were not necessarily, because you issue a summon to the directors or the promoters to provide the GST data is not justifiable. So it will go a long way in stabilizing or maintain the fairness of the investigation proceedings. However, it is very important to understand that when you are representing the organization, what sort of statement, etc., that you record, in terms to take the proceedings ahead. In other way, this is a welcome.
Absolutely. I think we are on time. It's 5 o'clock, so I will not let our participants take longer. But thank you, gentlemen, for this insightful discussion. I think some of the summary points to take forward from here is be mindful of your rights and duties. Don't panic. And that's something which is which is a common point raised by Gagan, Manoj, and you, Gurmeet, from the industry side. So don't panic.
Thank you.
Definitely look at where you have to be silent or come back when you have right to do that. So take that time, cooperate with the investigating authorities. At the same time, don't overcommit something which is not something which you would have otherwise done had you got that time or the opportunity to be consulted. And yes, seek consultancy wherever required within your organization or outside, but don't panic. I think that's what we'll take away from here in this. And from that, on that note, thank you so much, all of you, for this insightful discussion. I hope the participants, really got some insights in terms of the investigations. Happy to be addressing any further questions. Apologies if we were not able to address, but please write to us. You have got the email IDs here. Reach out to us, and we'll be happy to take up any discussion or any inquiry which you would like to have. And with that, have a good rest of your evening. Thank you so much. Bye-bye.
Thank you.
Thank you.